Hello, happy Tuesday, and welcome to Sidebar, your weekly 30 minutes with a 3L. Today, we're going to talk about case briefs and outlines. We're going to do it all in one episode because they're not actually that different. They're both concepts that no one outside of law school really uses, and they're not that difficult to understand. Case briefs build to create your ultimate outline. People talk about outlining a lot in law school. When I was touring law schools, back in my law school admissions days, the number one question that students seemed to be asking the 1L or 2L who was guiding us around the building was, how do you brief a case? What is a case brief? And also, what is an outline? Because everyone uses these terms in law school, and truly it's not any different from how you would study for exams and prep class notes in undergrad. So I sort of want to demystify these concepts for you. In the past few days, I was stuck in Arizona earlier this week because Philadelphia had a massive blizzard, and I'm so lucky I was able to find a Tuesday night flight back, and I got back to Philadelphia sometime around midnight Tuesday night, and then the very next day I had classes and other commitments. And so on one hand, I'm very happy that I got back at all, but I did miss class Tuesday. Funny enough, the Law Review does a trip every year to a city. It happened to be in Miami. And so I wasn't the only person that was stuck this weekend. A huge group of 3Ls and 2Ls that are very involved on campus or on Law Review were also stuck in Miami. And so it was kind of funny because I felt like it was like, if any, it was like a communal understanding that we were all just stuck elsewhere. Some of my professors were stuck elsewhere. And so it seemed like everyone was traveling last weekend too, which is crazy. But not a bad weekend to be stuck in Miami or in Arizona, let me tell you. By the time I got back to Philadelphia, we're having sunny days now. It's like in the 40s and 50s. It's an entirely different city now. And I think that maybe winter is finally over, and maybe finally it's springtime. But it is interesting when you're thinking about picking where to go to law school, or you know you're going to be moving far away from home, like especially in the Northeast, weather changes totally impact how the semester flows. And I know in the class that I TA for, we're constantly adjusting things because there's snow days here. And today is Friday, but we have a makeup class today. And yeah, being from Arizona, we've like never had to cancel anything due to any weather condition ever.
Welcome to Sidebar, your weekly 30-minute call with the 3L. We'll talk about all things law school admissions, law school, and big law.
So first, let's chat about case briefs. Now, case briefs are the notes you prepare after reading a case, and they contain a few important sections. Now, the most exhaustive version of a case brief is going to contain these different sections. The first is going to be facts, and it's going to be like, this is plaintiff, this is defendant, this is what they do, this is how they interacted and how the lawsuit began. And then after facts, you have procedural history, and that is who filed the complaint, what happened in the lower court, what happened in the Court of Appeals, where, like, especially if you have a case that went all the way up to SCOTUS, it might be important to note the procedural history. If the district court had a certain, like, dismissed or whatever their judgment was, and if the Court of Appeals reversed that, and then the fact that SCOTUS took cert, that's also important. Okay, so now we have a SCOTUS case, and we've been able to track what each court along the way has decided about this case. So after facts and procedural history, you're going to have the court's holding. I actually like to do the court's holding right after because I like to know yes or no. Did the court agree or disagree with the Court of Appeals or the lower court? I like to put that right after procedural history. And then I do the court's reasoning below that. And that's going to be the key points the court relied upon to reach its ultimate conclusion that you already wrote in the holding. Now, this is going to be things like, I'm trying to think of like an example. So in trademark, they might say like, yes, the mark was likely to confuse. And then they would rely on, oh, the mark was really strong. The marks sounded phonetically very similar to each other. This would all be part of the court's reasoning. And this is the part of the case brief that's very tricky because you could spend pages writing the court's reasoning. And the court literally did spend pages spelling out their reasoning. So it's very important that you try to distill this to the major high-level points. Otherwise, you're going to get lost in the weeds. And I think that's also why I personally like to write the court's holding before I get into the court's reasoning, because their holding, you're only going to write the court's holding that relates to the specific doctrine that you are discussing. So you're not going to talk about their holding when it came to civil procedure issues for a contracts class. You're really just going to talk about their holding for that doctrine. And so the court's reasoning should also only relate back to the holding that your professor or your class is actually focusing on for that case. After that, we have other opinions. And so especially if this is a Supreme Court case, you're going to want to know other dissenting opinions for sure. There's always going to be some big name dissenting opinion that your professor will probably want to talk about in class. And so I wouldn't jot down more than a couple bullet points, but I would try to capture their overall disposition of the case and also why they differ from the majority opinion. Concurring opinions are usually less important. If your professor really likes to deep dive into cases and all the different opinions, I know in con law we did that frequently, I would note who concurred, who dissented, and a few quick bullet points for each. But again, I would place a little bit more emphasis on dissenting opinions compared to concurring opinions, because there's usually probably only going to be like one point they disagreed with from the majority, which is why they concurred. Also, just to break all of this down for you, a concurring opinion is when they agree with the disposition of the overall court. So let's say that the majority found that there was trademark infringement. Now, that means that the concurring opinion also found that, but they came to that holding for different reasons than the majority opinion did, and they want to say what those reasons are. Now, a dissenting opinion means that they didn't reach the same conclusion as the majority opinion. That means that they found there is no trademark infringement, and they're going to list out why there's no trademark infringement. Now, it is interesting because on an actual exam, you're really going to just go with what the case said, and that's what the majority opinion lays out for you. You're not really going to deep dive into the concurring or the dissenting opinions, but I did have a few different classes where I would slip in a note from the dissenting opinion or like a concurring opinion into my exam response just to say like, this is probably what would happen, but note that under, I don't know, like Alito's dissent's line of reasoning, a court could find the opposite as well. It's a great way to slip in like a counter argument, and it really shows like mastery of a case and of the doctrine if you're able to raise concurring and dissenting opinions. But if you should not be doing this for every case, because this is it really, like, these concurring and dissenting opinions matter most when they're a really important judge, and this is the Supreme Court, or if the issue has been flip-flopping in general, like the doctrine is not super steady, and so like a concurring or dissenting opinion could almost like predict how the court will go in the future or how it would have in the past. Now, the first time you write out a case brief, it's probably going to be multiple pages long. I really recommend typing it up, because when it's time for you to convert your notes to an outline, you're not going to be able to just handwrite everything. And so if your class is a no electronics class, or if you're the type of person that strongly prefers to have paper notes, I think that's fine. Type it all up and then handwrite it out afterwards. Again, like, I think that you can make the opposite work. You can read a case and then handwrite out your case brief and then type it up. But I think that by the time you reach the handwriting it out portion, you really only want to focus on the most important key points. And again, chances are that first month that you're going to spend nailing down how to read a case and case briefing, you're going to write way more than you need. And so just type it out, and then you're probably going to delete half of it once you're done fully reading the case, and then you can write down what's left in your notebook. Also, I spent that first month, like, as I was reading the case, I'd have my textbook here, and then I'd have my notebook here with my case brief, and then I would fill it out as I read it. And I think that's fine, and that's probably how you're going to start doing it. But then I got to a point where I felt like I understood how to read a case well, and I would often go to like a case brief system like online, and I would read the case brief, understand the key doctrinal takeaways, prep my case brief then, and then in reading the case, I would add information and chunk up the existing case brief I already had. And so that, like, it forced me to have an overall structure and framework to my case brief. And then when I was reading, I was basically just confirming my understanding of the case. Starting law school in the fall, yes, like September, definitely read your cases and then write out your case briefs. But also in January, in the spring, even when you kind of got down how to read a case, I still recommend like actually reading the case. And I think like in the middle, towards the end of the semester, when your focus starts to shift more on big picture and outlining, I think then you can kind of like loosen up on dedicating hours to reading the cases and really just make sure you understand it from the case briefs that are available online. Create a good case brief yourself, and then you can like what I call heavy skim the actual cases. Because, and like, truth be told, if by October and November you're spending hours and hours reading every single case and you just will not have the time to outline or understand the doctrine at a super high level. And so that's why I don't think it's the best use of time to read every single page, spend hours doing that, hours creating your notes when there are case briefs available online, and you should probably reference those first, just so you have a more precise, focused reading of the actual case. It's working smarter, not harder. You're reading the case and you're also reading a case brief online. So in some ways you're referencing more materials. And again, it's just so you can get that like targeted reading and confirm your knowledge of what you already read on a case brief system online. Also, if you're the type of person that likes to read every single case and doesn't want to have something online, I really respect that. And I have a few friends that were pretty adamant about that, and they never changed their system. And so I say all power to you. Also, I should mention that you in law school, it's really different from undergrad because you don't have exams throughout the semester typically. You usually just have your final at the end of the semester, and it's typically worth 100% of your grade. Yes, 100% of your grade. It's insane. And I think when you get into upper level courses in law school, it stops being that way. There's maybe like a group presentation or participation grade or various other assignments, but typically your first year, those true 4-credit doctrinal courses, they are 100% based on your final. And so it is absolutely imperative that as your semester progresses, you don't stop case briefing entirely. Even if you're not fully dedicating the time to read the case, you need to have a case brief for the cases. And maybe there's people out there that are listening to this and they're like, I don't do that and I still get good grades. And I say all power to you. But if you're also like me listening to this and you know that you're not the type of person that can just like magically get ahead without putting in the work, I highly, highly, highly recommend briefing each case. Have something in your notes for each case. Outside of using a case brief system, for a lot of my classes that were difficult, I would also rely on Hornbooks. And Hornbooks are books that kind of introduce and get into the doctrines at a high level. I don't really start a semester by reading Hornbooks. I'll typically start reading it a month or so before I start outlining, or at the same time I outline. So let's say your very first topic in a certain class, let's say con law, is standing, or Fed courts. I think they both begin with standing. I would get the Hornbook for that class, and it will probably start with standing. And I'll read that. Most likely I'll read it after the professor's already gone over it. And then I'll be like, oh my God, I finally understand what this is about, because chances are class didn't do it for me. And then I'll probably start outlining. So it's sort of this in-between step. And so to put it all in order, you read your assigned reading and you prep a case brief for it. Then you bring that to class and your professor's going to focus heavily on some things and less on other things. And you have your class notes. And then you have outlining, which is when you look at your class notes and your reading and you make it all into some like cohesive document. Class notes are integrated with your reading notes, or what I typically do, I keep my class notes and I'll integrate the reading notes into my class notes. And that's like the process of outlining. I'm recommending that you read a Hornbook before outlining. And this, like, save this for classes where you're really lost and confused, because if you're going to read a Hornbook for every single doctrinal you have, that's very ambitious. And it is a whole separate textbook from your actual textbook. So I did this for evidence because I was like, I really want a good grade in evidence. And I've just found that when I do this Hornbook early outline process that I'm about to lay out, like, I always end up getting a good grade. And so I love a Hornbook, especially if, you know, your professors oftentimes are going to be extremely smart, but maybe they're not going to be the most effective at communicating information over onto you. And so I think the Hornbook writers are pretty good at writing and explaining concepts to students. And so I highly recommend. There are a few other resources in lieu of Hornbooks. Like, I know that Barbary has really good civil procedure videos online. And so if you're less of a reading person, which I get, and more of like someone who likes to listen to things, I would probably look into that as well. There's like online lecture series covering different doctrinals. Now, to go back a little bit, after you've finished your case briefs and then you bring it to class, I have like separate class notes most of the time than my actual reading notes. And I find that like half of my reading notes probably are not important. And the professor only emphasized a few things. And this especially is true in like September, like your first month of law school, where you just have insanely long case briefs. And then you realize your professor only really cares about a few things. So by the end of that first month of law school, I encourage you to make your case briefs for each case like a page long max. Try to shorten them as much as possible. And then in class, whatever your professor focuses on, I always say like professors are kings of their classroom, they're kings of the exam, kings and queens. Even if you feel like something's not that important, you personally feel like it's not important, or maybe your friends in other law schools didn't focus on a certain case, your professor dictates what's important to them for that subject. And then the exam is going to correspond with that. So I think class notes are definitely more valuable. Part of the value of having case briefs like reading notes is also, you get cold called in class. And maybe I'll do like a separate video on how to handle a cold call. But to be honest, I think I would sum it up as like, just don't care as much about public embarrassment. Maybe get used to getting embarrassed in class and getting embarrassed in front of your peers. I think I frequently got embarrassed in cold calls because I never really have it together. And I'm very bad at speaking on the spot like that. But I try to get it together by the end of the semester. And so, yeah, maybe I like didn't have the best knowledge coming into some of these classes in terms of what I read. Probably because I wanted to sleep 8 hours more than I wanted to read every single page of the reading like perfectly, or that my brain just stopped working by the time I read it. But, I tried my best, especially 2L on, to fully pay attention during class and really understand what the professor was saying in class. And that is very hard to do, especially when you're allowed to have electronics and it's so easy to be doing things on your laptop. Sometimes I would like fully turn my Wi-Fi off, and my notes were offline. So I could just be on my notes and just be locked in. So again, for some classes, I'd modify the reading notes case brief that I already had. But most times, like 9 times out of 10, I just kept separate notes, especially if that professor had a PowerPoint. I would typically try to copy over everything in the PowerPoint and then build on that from whatever we said in class and then incorporate my reading notes into that. And so when you begin outlining, you are really just combining all these different sources of information. And I'm going to call this like your exhaustive big outline. It's going to be a long running document of organized by doctrines from start to finish of the class. And ultimately, for your final exam, you're going to be able to print it out and bring it to class, or you're going to be able to have it on your laptop. And it's very important it all be in a single document. There are some classes that are no materials allowed, including outlines. I still recommend making an outline because the process of outlining will force you to organize all of your notes into the doctrines and understand how the doctrines relate to each other, big picture. And so let's take common law, for example. You're going to start by outlining standing. You're going to work from the beginning of the class to the end. And I think if you can, starting to review your notes and starting to compile it together, I think it's good to do that after your first full month of law school. I know that sounds early, and I'm not telling you to start outlining yet, but at least read over everything and figure out if you understand standing. And then let's say it's like early November or it's end of March and you want to start putting together your outline. It's going to be a lot easier because all these various sources of information, so like notes you might have had from your Hornbook or reading notes or class notes, they're already kind of going to make sense to you. And if you were able to incorporate your reading notes and your class notes into one document, like at the end of each week of class, that's even better. When it came to Hornbooks, I would just read the unit before I started outlining, and I didn't really take notes on my Hornbooks. I would just read it. I think taking notes on the Hornbooks is maybe like too much of a commitment, to be honest. So I would like read the mini unit, outline the unit with the Hornbook fresh in my mind, and I would really just take the lecture notes and then incorporate reading notes at the end. And for some reason, it takes me hours to outline a single unit. And I don't know if that's true of everyone or if I'm just really slow. So just know that, like, if you're planning on creating an outline from scratch in a couple of days, it's probably not realistic. Again, there's probably going to be some people that listen to this and they're like, oh, I did that every single semester. And that's amazing. But maybe your first semester, don't bank on being able to work at superhuman speed. And I think there is some merit in, like, if you work slowly and you outline, you're probably going to remember it more and you're probably just paying more attention, to be honest. I would give myself like a unit a day. And I think my first year I started during spring break because I didn't really do anything fun for spring break. I went to New York one weekend, but I had a few days downtime, like 3 or 4 days. And so I did like a unit per class per day. But there have been times where I just wanted to finish one class's outline before even starting the other. And I think that's like a crazier approach. I probably wouldn't recommend it. But if you know you really care about some classes and you care less about others, again, this is like the sort of weighing decisions you have to make. I know I really, really cared about Intro to IP and Con Law my spring of 1L. I just really liked both classes. And so I remember starting their outlines early because I was like, this feels like something that I want to be doing. And if there's like one class you can start with because it feels like less intense, start with that class. And so outlines, again, are organized by doctrine. So you're not really going to say like, oh, on October 13th, we talked about this. Oh, on November, we talked about this. That's not how it's going to work. It's going to be by the major sections in the class you're learning. And so if you're confused about what those sections are, I would recommend looking at your syllabus and looking at how your professor laid out the different doctrines. And those should form like the major headings for your outline. Now, I think this exhaustive outline is great. It's going to help you learn everything. That's really its major value. On the actual exam, you're going to have like a few hours. You're going to be working at lightning speed. I rarely have time to flip through my big outline on actual exam day. So now I'm going to talk to you guys about different types of outlines. So another thing I wish I knew my first semester of 1L was that the most important document you can bring into exam day is something called an attack outline. And again, there's going to be people that are like, I've never made one in my life. I'm like, and to them I say, you made your life harder. If you can create 1 to 2 pages of a document that almost functions as like a checklist of the topics you should be hitting, that's what you want come game day. Because your professor is going to hit every single one of those major units at some point on the exam. And so this attack sheet for me functions as like a checklist. Did I cover standing? Did I then cover all these issues? Did I cover defenses at the very end? When it's time to write your exam, it's going to be some big issue spotter with some open-ended questions, and it's really up to you to flag everything that could possibly be relevant. There are very few situations where your professor is like spoon-feeding you the issues to flag. Like, oh, what is the standing problem here? Oh, what is the this problem here? That never happens. Usually it's like, it's up to you to flag everything. And that's kind of like how it works when you're an attorney and a client comes to you, because they're not going to be like, all right, so now what about this doctrine? It's up to you to figure out what doctrines are even important, right? So it kind of makes sense. I think like it feels a little cruel if you're not used to it, because it's like, if you just asked me the question, I would have been able to answer it to you. But instead, you want me to lay out everything that could possibly be relevant. Well, that's where the attack outline comes into play. So this is going to be just a couple pages. If it stretches to over 5 pages, it's probably getting way too long. I've seen some really good attack outlines that are like literally checkboxes that cover from start to finish all the doctrines, and also have like sub bullets for if you have these facts, standing comes out this way. I think it's really effective when for each doctrine, you list out the requirements so you can go through them one by one. Now, the attack is not the place to discuss cases at all. If you're going to even mention cases, they're going to be like one sentence. Like it's going to be like the plaintiff's name after the end of a sentence. So like, let's say one of the requirements for standing. Then after that requirement, you would write down like the case that you guys talked about in relation to that requirement. And let's take trademark, for example. There's 6 likelihood of confusion factors. One of them is strength of the marks. So if there's this 1 or 2 cases you guys talked about a lot for strength of the marks, I would put those right next to the strength of the mark bullet and just put a colon separating them. I'm not going to talk about what the cases said, because if I can't remember at all, I would go back to my big outline. I'm just going to note that that is one of the factors. And on my exam pattern, I'm going to say strength of the mark comes out this way. This case is like whatever, X or Y, the 2 cases that I listed. Now, the attack outline I usually don't build until after I've taken at least one practice test for a law school exam. So it's really only after I've taken like one practice test that I'll sit down and actually create this attack outline. But come exam day, I like to have my reading notes, I like to have my big outline, and I like to have my attack. And my attack is like to the left side of me, my exam is to the right. And you can make your attack a few days leading up to the exam. So there is also something called pre-writes, and some professors will explicitly tell you to bring pre-writes to the exam. I had a professor that did that. And so I think the best way to build pre-writes is to take your attack outline and almost like write it out. So say like there is strength of the mark here because, and then list out a bunch of factors that would make it strong. And then underneath that, you would say strength of the mark is not met, or this mark is not strong because, and then list out a bunch of factors that would make it weak. And so you're basically like applying the rules that you laid out in your attack as if it was for an actual fact pattern. And you're kind of writing one in the affirmative and one against. And it's like, honestly, I don't love the idea of pre-writes because I feel like on an exam, you should be able to like write it out yourself. And it almost feels like cheating because you're preparing your exam response before you even get the exam. But I have had some professors explicitly tell me to bring in pre-writes. Not just me, but like the entire class to bring in pre-writes. And so I did want to mention that. That, like the attack, is something you can build just a few days on the weekend before your exam, or if you have a reading period during that time. Now I want to talk about like high level, some do's and don'ts. Let's start with case briefs. I think if you're having case briefs that are way too long towards the middle and towards the end of the semester, that's going to be a major disadvantage to you because it really, each case is going to boil down to a few important points. And if you have way too much content, it's going to make the outlining process miserable. And I'm also worried that you might not understand why a case is important. In legal writing, you see this all the time. When someone's writing out a case illustration paragraph or like describing a case and they include all these facts that are not important, it worries me. And when I see myself do it, I realize like, oh, I don't actually know what the most important facts in this case are and what actually relates back to the court's holding and the court's reasoning. And so truly everything can be boiled down in just a few bullets. Also, when it comes time to outline, I really don't recommend grabbing the facts of the case and bringing that over. If anything, maybe like in one bullet, summarize the facts of the case. And I'm not saying you have to have the facts of the case memorized. I'm more so saying it kind of doesn't matter. What matters is the facts that the court discussed in its reasoning to reach its holding. And if you think about, honestly, the best way to explain this is like if you think about what you would include in a case parenthetical for that case. Now, in a case parenthetical for legal writing, you have to have the court's holding, reasoning, and important trigger facts. And trigger facts are the facts that if they were different, the court would have reached an opposite holding. And so what mattered and what didn't? Like that is the ultimate question. So if you can in your mind, when you're reading a case and determining what to even write in this case brief, and then especially what to bring over to your big outline, think about what you would say in one sentence about this case. And so this is what I mean where like, especially when it's time to put together your outline, you just use so much of your brain and your thinking. It's not just like passive, like copying over text into this outline. It honestly requires a lot of thinking and work and like making sure that you're accurate in what the important facts and court's holding and reasoning and all that stuff is. You need to make sure you are accurate. Because I think the impulse to have long case briefs or to spend a lot of time talking about a case on an outline comes from not being sure why the case is important. Okay, another note on using other people's content for case briefs or for outlines. I think using other people's stuff is very helpful. And there's a reason that there's outline banks in law schools, and hopefully people are connecting you with good outlines. And I think they're always a great first reference point, just like case briefs. It's always great to read those, often before you read the case yourself or before you outline yourself. But I'm a big believer in modifying things to suit you and not just fully depending on someone else's stuff. Because the case briefs online are going to miss some important facts or not understand that your professor loves this certain judge's opinions. And so they're going to bring up that concurring opinion all the time. And they're going to pay special attention to the cases where that particular judge was the one that wrote the majority opinion. And so they're not going to understand the nuances of that class. And so commercially available case briefs are great. I use them all the time. Yeah, they should not 100% be what your final case brief is. Similarly, for outlines that you take from others, like past students, I see this frequently. Some doctrines might be straight up wrong because they've changed in the past few years. And the last time there was a really good outline that a student wanted to publish in one of these outline banks, the doctrine was different. And if you're in con law, you know things have changed a lot. Admin law, things have changed a lot. So if you know you're in a class where things are constantly shifting, be very careful about updating your outline to reflect this new case law, and realize that your exam responses are going to differ from ones that have done well in the past, because these new cases have completely changed the trajectory of how something would now be litigated. So this issue spotter is going to come out like the opposite way. And so again, it's important to note how things once were, but then you have to say, oh, but with existing, after this case, after this case that overturned this other case, this is what the situation would look like now in courts. Also, as much as you can, this is like tricky. Towards the middle of the semester, I think there's should be a shifting towards spending less time reading cases and more time reviewing your notes from class, reviewing your reading notes, putting together your outline. And I absolutely think that exam prep should be your absolute focus that last month before exams. And so forgive yourself if you're not able to fully comprehend what you're reading, or you're going to have to skip some cases and they're not that important. Law school is all about making tough decisions and being smart about it. You cannot do everything that the teacher lays out for you, or everything that I'm even telling you to do in this episode. You're going to have to pick and choose what is highest value and most time effective for you. And remember, it all kind of boils down to one assessment. So take what works and leave what doesn't. But I hope that this helps you understand at a high level what case briefs are, what outlines are, there's different types of outlines, and what ultimately matters when it comes to exam day. All right, see you next week. Bye.